Do I need an attorney? Yeah. Do I need an attorney to represent?
Yeah. Truth be told, you aren't required to have an attorney represent you. That being said, what you should know is if you decide to go out and handle the case on your own, you're going to be up against an insurance company and an insurance claims adjuster who is more likely than not going to have a whole heck of a lot of experience in dealing with these types of claims and defending them to the point where it's probably to your disadvantage. The insurance companies are trained to tell you that they're there to try to help you, they want to see you get better, and that they're going to take care of you. But how do you really know for sure that they are taking care of you and whether they have your best interests at heart when you're the one who is sitting opposite their interest? We certainly recommend that people come in at least for a consultation to determine whether they need an attorney. And if you decide to hire an attorney, you will know that you've got someone who is protecting your interests, who does have your back, and someone who has the experience necessary to deal with the insurance companies and their claims adjusters to make sure your interests are being best served as opposed to the insurance company taking advantage of you.
To retain an attorney?
Yeah. One question I get asked a lot is how much is it going to cost for me to retain an attorney? And the nice thing about the world of personal injury work is it doesn't cost the client anything up front. We here at Black, Chapman, Weber and Stevens perform our cases on a contingent fee basis, which means if we don't obtain you any money, we don't get paid an attorney fee. And the nice thing about that system is most folks who come in can't afford to pay up front or as you go along for an attorney. People have been injured, they're hurt, they can't work, and so to ask them to pay as you go, so to speak, is rarely going to be able to be accomplished. By working on a contingent fee basis, the client has the comfort and the knowledge that, number one, they aren't going to be sent a bill every month for our services. Number two, and perhaps more importantly, the client should know that if my attorney's working for me on a contingent fee basis, my attorney is probably going to want to do well, because not only am I going to get paid, but my attorney is going to get paid. And that's the big difference in a contingent fee basis system as opposed to working hourly, where you don't know for sure if your attorney really cares about whether he wins your case or not, if he's still going to submit you a bill regardless of the result of the case. The time it takes to settle a case is going to differ from client to client. Some people will get better in a very short period of time. Some people may not be completely better by the time the statute of limitations expires. Some people may never get better. So that is an important element in terms of determining when to settle a case. For instance, if someone gets better in a few months, they go back to work and they're able to do everything that they could do before the accident, it might be appropriate to settle the case within months thereafter. If someone has a major surgery, I may encourage that client to go back to work for a good period of time and make sure that body part doesn't give you further problems. The reason you have to deal with this on a case-by-case basis is you only get one opportunity to settle your case. You have a statute of limitations, which is typically for personal injury cases 2 years. You want to make sure you use that time wisely, because you only do have one opportunity to settle it, and if you settle it too soon and that client has problems later on after the case is over with, you can't go back and help them again.
Is there a way to know how much my case is worth?
In the beginning of a case, clients want to know sometimes how much their case is worth. I personally believe that it is wrong to sit there and tell a client how much their case is worth without having had an opportunity to review their medical records and every aspect about their case. How can you possibly know how much someone's case is worth at that time? Furthermore, if someone is still hurting You don't know if they're going to get better in weeks, months, or even years down the road. And all of those will factor into how much a person should be entitled to receive for their harms and losses. Usually the point where we start talking about with the client how much their case is worth is when we get to a point where we're going to try to settle the case. Perhaps before a lawsuit is filed, the client is better. We've got a complete, or as complete as possible, understanding of what, what their treatment has been and what their likely value of their case is. That's usually the first time when I can sit down with the client and tell them what their case is worth. And the same process applies if we go into court through the litigation process. There will likely be opportunities to settle the case, again, at which time you can talk to them about how much their case is worth. And if the sides can't agree on how much their case is worth, we always have, as a last resort, the ability to go in and have the case tried by a jury of my client's peers.
Yeah. How would you phrase the question then?
You could probably just say something as simple as one answer.
You answer it however you want.
Okay, this one might be a little longer than others, so here we go. Typically, we will settle about 2/3 of the cases that we have without the need to file a lawsuit. That's because the insurance companies and our clients are able to agree on amounts that are reasonable to settle the case for. For the remaining 1/3 of the cases, those will go into litigation. We will file a lawsuit, make sure that the defendant is served, and then we will begin the formal litigation process. For those cases that go into litigation, most of those will settle as well. And there will be a very small number of the entirety of the cases we have that do actually go to trial. And sometimes folks want to know, why is my case going to trial? And there are usually 3 reasons. They can be exclusive or intermingled as to why cases go to trial. There can be a dispute about who was at fault for the accident or whether there was any fault for the accident. Number 2, there can be a dispute whether my client's claimed injuries are due to the accident that we're suing for. And number 3, which is almost invariably at dispute in the case, is how much is the case worth dollar-wise in terms of reimbursing our clients for their harms and losses that include their medical bills, their wage loss, or their pain and suffering.